The case Basevitz versus Fremont School District involves constitutional violations of the Establishment Clause. The Establishment Clause of the First Amendment is the very first phrase of the First Amendment of the Bill of Rights. And the Establishment Clause states that the government should not establish a religion, basically meaning that it should not be in the business of promoting religion or of establishing churches. In the Basevitz case, what happened was a high school had given free rein to a local pastor to conduct religious activities, and these religious activities were joined in by school administrations. That's a very, very clear governmental endorsement of religion because it sends a message to the students and anybody else who would see these activities that the public school is in the business of promoting this particular church. The number of violations at the school was really amazing. On a single day in the spring of 2004, the school sponsored no fewer than 5 different religious activities. There was a prayer ceremony in the morning. There was a prayer with lunch ceremony. There were 2 different all-school assemblies where a school-sponsored Christian rock group made a presentation and presented scripture to students. And there was a meeting in the auditorium where the principal and the pastor passed out Bibles to students. There were weekly lunch sessions with the pastor where children were prayed to before they could participate in the pizza that the pastor was offered to them. The kids called those Jesus Pizza sessions. Mr. Basevitz had complained about these constitutional violations internally. He had done his best to raise his concerns as the only Jewish member of the school administrations and staff, that he thought that the school had gotten into the business of promoting evangelical Christianity. And instead of the school acknowledging what were very clear violations of the Constitution, they basically just brushed him aside. After Mr. Basevitz had attempted to resolve these issues internally, he filed a formal complaint. And shortly after he filed his formal complaint, he was transferred to another school. I thought, as soon as I talk to the school district's attorney, they're going to want to resolve this case because the violations were so incredibly clear and documented with photographic evidence. The school district was unwilling to acknowledge plain facts about the violations that were occurring. The primary purpose of the lawsuit was to force the school, force the superintendent, force the administration to stop engaging in these very clear, very egregious violations of the Establishment Clause. We took our case to the press, and the press and the public weighed in very, very strongly in our favor. Our hope was that by shining a bright light on these constitutional violations, that the school and its council would wake up and hear neutral third-party voices weigh in on these violations and understand that what they were doing was plainly illegal. After we pursued that media campaign, the school district's tone changed very dramatically. Once it became clear that the district's position was untenable, that any court fight was unwinnable, and that the court of public opinion was strongly against the district, then we were able to convince the district to enter into this consent decree, whereby all of the activities that it had previously been engaging in were no longer permitted. The federal government, the state governments, local governments are not in the business and should not be in the business of promoting one religion or favoring one religion to the exclusion of all the others. And protecting the rights of religious minorities in the workplace and in our public schools is a very important part of ensuring that we push back back against efforts to marginalize religious minorities.